There's a certain kind of tax planning that business owners have heard about for years. Some people call it a pipeline, others call it a capital gain strip. And the idea behind it has always sounded tempting. If you have money sitting inside your corporation, why not take it out in a way that's taxed as a capital gain instead of a dividend? For someone who has spent years building a business, the difference in tax can be huge. But Canada's tax system has its own way of looking at these transactions. And one real court case shows exactly how these steps are examined. That case involved a medical doctor from New Brunswick named Dr. Robert G. MacDonald. And it became one of the most important surplus extraction cases in Canadian tax law. Before moving to the United States in 2002, Dr. MacDonald needed to wind down his professional corporation. This corporation held about $500,000 in cash and near cash assets. Like many business owners preparing for a major transition, he wanted to take that value out of the company. With advice, he used a series of steps that, at that time, many practitioners viewed as a possible way of turning what would normally be a dividend income into a capital gain. So his brother-in-law personally bought the shares using a promissory note. Those shares were then transferred into a newly incorporated holding company. The professional corporation declared dividends to the holding company. The checks flowed from the company to the holding company, then to the brother-in-law, and eventually back to Dr. MacDonald's as repayment of the note. After these steps, the company moved towards a dissolution. Dr. MacDonald reported the amount as a capital gain on the sale of his shares and applied capital losses to offset it. The CRA reassessed him under Section 84, subsection 2 of the Income Tax Act. For business owners, the practical meaning of that rule is straightforward. When a company is winding down or reorganizing and corporate funds end up in the hands of a shareholder, the law may treat that amount as a dividend, even if the steps look indirect. Dr. MacDonald appealed to the Tax Court of Canada. The Tax Court reviewed everything step by step. The court found that he received money in his capacity as a creditor because of the promissory note and not as a shareholder. On that basis, the tax court said Section 84, subsection 2 did not apply. The court also examined GAAR rules, the General Anti-Avoidance Rule, and found that GAAR did not apply on the facts before it. For many years, this created a belief among tax practitioners that pipelines might still work if structured carefully. People often said that as long as the corporation continued operating for some time after the reorganization and the steps were sequenced properly, Section 84, subsection 2 might not apply. And others pointed out that the tax court's comments about GAAR were never overturned, which created an impression that GAAR might not be the main threat in this case. But when the Crown appealed the case, everything shifted. So the case went to the Federal Court of Appeal, which reviewed the same facts but focused on the overall economic reality. The court emphasized the phrase, in any manner whatever, in Section 84, subsection 2, which is extremely broad. This meant the court could look beyond the legal labels attached to each step and instead examine how the money truly moved during the winding up. The court noted that Dr. MacDonald had been the original and sole shareholder. He initiated the wind down. The corporation sold its investments before the plan was carried out, and at the end of the series of transactions, nearly all of the corporate money had ended up with him, which is Dr. MacDonald. The court referenced earlier decisions such as Merit Smythe, and RMM, where similar patterns were treated as distributions to shareholders during wind-ups. Because, based on this reasoning, the court concluded that Section 84 subsection 2 applied. Once that rule applied, the court did not need to comment on GAAR anymore. This decision became a major reference point. Even though the tax court's GAAR comments were technically untouched, the appeal court's interpretation of 84 subsection 2 set the practical boundaries for pipeline planning over the next decade. For several years after the case, many practitioners believed that if a pipeline could be structured to avoid 84.2, typically by ensuring real continued business activity for a meaningful period of time, the planning might still work. But then the law changed again, and this time the changes were far more significant. In 2024, Parliament amended GAAR. One of the biggest changes was the introduction of the concept of economic substance. Under the amended GAAR, if a transaction significantly lacks economic substance, in other words, if it does not change anything meaningful in the real economic world and mainly changes the tax outcome only, that is now a strong indicator of misuse or abuse. And this is important because many capital gain strips rely on steps that change the form but not the substance of the transaction. Another major change was the introduction of a GAAR penalty. When a transaction is subject to GAAR and was not disclosed under the mandatory disclosure rules, the penalty is roughly 25% of the tax benefit. So if a taxpayer saved $100,000 through a structure and the CRA applied GAAR, an undisclosed transaction could result in a $25,000 penalty. But the changes did not just stop here. The amended GAAR also extended the reassessment period when a GAAR-related transaction is not reported. This means the CRA has extra time now to reassess the transaction, which increases uncertainty for business owners. Alongside the amended GAAR, new mandatory disclosure rules came into force recently. These rules require certain arrangements to be reported to the CRA using Form RC312 when the arrangement contains specific hallmarks. The rules use a very broad definition of an advisor. So anyone who provides assistance, input, guidance in designing, planning, organizing, or implementing a reportable transaction may fall within that definition depending on the facts. The key is involvement in planning or implementing the arrangement, not routine compliance. The reporting deadline is 90 days from the earlier of entering into the transaction or becoming contractually obligated to proceed. If reporting does not occur, penalties apply. For taxpayers, penalties can be $500 per week up to $25,000 or $2,000 per week up to $100,000 for larger corporations. If GAAR applies to an undisclosed transaction, the penalty is roughly 25% of the tax benefit. For advisors and promoters, penalties may include 100% of the fees related to the planning, a $10,000 base penalty, and $1,000 per day up to a cap of $100,000. These penalties highlight how seriously the government views non-disclosures of certain types of planning. Planning ahead always creates the best outcomes. Thanks for watching, and I'll see you in my next video. Until then, bye.